Hello. Mooting refers to factual court. It's like a legal proceedings where participants, typically law students, argue, and there are hypothetical cases, and it's a competitive activity that helps a student develop advocacy skills, including legal research, argument formation, and courtroom decorum.
Yes, pretty well answered. Mohammed has answered sort of simulation of a real court hearing. That's correct. That's also correct. So yeah, Zarsha, can you please read this slide for me?
Yes. A moot court competition simulates a court hearing in which participants analyze a problem, research the relevant law, prepare written submission, and present oral arguments. Moot problems are typically set in areas of law that are unsettled or that have been subject to recent developments.
So yeah, now the first line of it says that it simulates a court hearing. So moot court competition or moot court generally is something that teaches you about the real court experience at the first hand. What happens is that why people emphasize on it, because for law student it is really important to understand what does court looks like, or what does it entails to be in court. The later part of the same definition says that in which participants analyze a problem. Now here is the some sort of real lawyering comes in, where you get a problem and you get to solve it in real practice, and after the graduation you'll get real problems. But in moot court you are taught to handle such problems, those which some of them may be real, some of them may not be real. So what happens is that you get a problem, you solve it, you research on it. Amantha has answered fictitious dispute where competition participants. Perfect, that's it. So you research on a relevant point of law, whereby you prepare a proper written submission, and then you get to plead the same in the court itself, which is not the real court, but it has everything that the real court has. So what in a moot court is a full package that teaches you what litigation looks like. If some of you may come to the courts, get a cases, solve it, and submit a written submissions. Now in that scenario you get to learn everything. So the time period from getting a moot problem till the participation, till the preparation of it, and also after last stage, which is the oral pleading. In these stages you learn different points where you get a problem, you solve it, you prepare it, you submit it. Now all these 4 stages are one of the most important stages for a lawyer to learn. So that's what moot court is, a full package that teaches you about the real court experience and about the real litigation, what it is. Second thing it teaches is the advocacy. Now advocacy is one of the most important skills for a lawyer or for anyone who is doing the law. Advocacy is a skill that in which you learn how to perform in a courts. Now I go to courts every day and I take it as a performance. So to understand that if you're presenting a case, you are performing a role, you are performing a particular skill, which is the advocacy, which is the presentation of your case. So understanding of it, that I am here to perform, I am here to present a case in a particular way that the judges could understand, that is concise, that is a clear and organized and efficient manner of presentation of your case. Now all of these words you might have heard everywhere, but those words are one of the most important skills that you need to have. In a clear manner you have to convey your case, you have to present your case, you have to organize everything. We do a lot of research in moot court competition. What happens is that all the research comes to a point that all of the research it becomes a bunch of arguments that we try to present before the court. We have to be very clear and organized with our research, and that is what in the process of mooting, we learn in the real life as well, real life cases as well. You will get to know and understand that what evidence is important and what evidence is not important. So this is the skill which is called advocacy, whereby you get to perform your skills, which are concisely presenting your case in a clear and efficient manner. Second thing is that why mooting, why you should be mooting, why should focus in mooting during your law school. Since this session is an introductory session for the mooting, I would like to make you all understand that mooting is one of the most important activity that you could do in law school. It is not an extracurricular activity, it is part of your curriculum. If it's not, but it is impliedly part of your curriculum, it should be part of your curriculum. Hamare yahan to it was part of our curriculum in final year. I don't know about you guys, but it has to be, it is really important. It should not be called as extracurricular activities. You all should be pretty much focused on it, just like on the other subjects, or perhaps even more on it, because this teaches you a very practical skills and practicality of this profession. Now, why you should be doing mooting is that you get to understand very important legal principles. We are in first year, we don't have a subject of international law, but if we are participating in a moot court competition which is based on international law, you'll have to learn international law to that extent only. It's not that you have to learn all the international law. Often we get scared that in a first year, how are we able to how are we able to just study the international law? We are not able to. There is a limited amount of it that you have to learn during the moot court competition, and it surely is not a pressure. Now, understanding the legal principles, some of you may stick to your textbooks, but it is really important for us to understand what are the legal principles, what is going on around the world, what is the new development on the law. Most of the moot problems are based on the development of the basic developments of the law, and if you try to participate in those, you get a clear understanding of new legal principles that are really important and helpful as well. Subsequently, you develop skills, you develop excellent skills, you develop such a skills for your entire life, for your entire career itself. These are skills that will help you in all aspects of your life, even if you don't continue litigation or continue going to courts or continue this lawyering. So it teaches you research, writing, advocacy skills essential for your legal practice. You do corporate, you do litigation, you do commercial work. All these skills are really, really important in your career, in your legal practice. And those skills are not taught in law school. We give 5 years, 3 years in law school, but nobody teaches us how to write a case, how to present a case, how to research a case. We are taught from textbooks, but no one has ever taught us these skills, and no one will. You have to understand that these skills you will have to learn all by yourself, because our law schools are not equipped to teach us these skills perhaps. Second thing that it says preparation for practice. All the points are pretty much connected to each other, that it prepares you for the practice. Now, students get the real world litigation and legal proceeding, providing a safe environment to develop or test your skills. Now, mooting is a place where you get to test your skills, you get to learn new things, and even if you don't know about certain things, or even if you cannot do litigation, even if you are not a good speaker, you get to develop those skills in the meantime. And that is the time where you can just test your skills. If you're not good at it, you will get to learn new skills. You will have chance to make mistakes and learn from those mistakes, and people will be there to teach you in that sitting. Otherwise, people are going to criticize you in the legal career. If you make such mistakes, you will get a strong criticism. But if you test your skills, that whether you're a good researcher, whether you're a good speaker, whether you're a good performer, those skills you can only test during these participation and during these activities. Now, what is the format of moot court competition? How it is? I guess people here need to know the basics of it. So I would like to say that I would like to focus on what is the format of the whole competition usually. And format includes two parts. First, written memorial and oral arguments. But with that, I will also explain you the first stage, which is the team formation. Now, before actually participating in a competition, you have to form a team. You have to get your team registered in a competition so that you get a moot problem and other things as well. Competition like Jessup and Henry Dunant, they don't give us moot problem. They don't even know competition discloses their moot problem before the registration. So teams have to register, and to form a team, you have to understand that what are the people who actually are going to work as a team. And each team member has its own responsibilities and own burden. The competition cannot be. You cannot win this competition on an individual level. You have to work as a team, and sometimes there are 3 participants, sometimes there are 5 participants. So all these participants have to play their role very efficiently and very supportive of others as well. So yeah, formal stages include written memorial submissions and oral arguments. Now you get the problem, you work on it as a team, and then you prepare a whole memorial. Now each team will prepare 2 memorials, one on the applicant side and one on the respondent side. So the team member themselves will prepare each team will prepare 2 memorials, and those memorials will get exchanged one night before the competition with other team members as well. And after submitting the memorial, oral arguments comes to play. Now, whatever you have written, whatever your research was, now in an oral arguments, you get the chance to present that research before the bench. Before written memorial and oral arguments, I would say there are some of the competitions like Nuremberg, Henry Dunant. Such competitions have preliminary requirements as well. So you will have to submit preliminary answers to the questions they have asked. Without that preliminary stage, you cannot have a moot problem in these competitions. So those preliminary questions are equally tough and equally difficult, as well as important for you to ensure your participation in that competition. So some of the competition might have these preliminary questions for you, for the participants. So the criteria of selection in such competitions is very limited, and plus these competitions are such big competitions that everybody wants to participate in these. Now, in memorial submission, what happens is that teams submit detailed arguments, memorials outlining their legal positions, demonstrating their research, writing skills. Each team will submit 2 memorials. Like I said, each team will submit 2 memorials, and one for the applicant, one for the respondent. Now, in this stage, a whole solve moot problem will be presented to the organizers. Every moot problem will have certain issues, the questions that we call them issues in a language of moot courts. So those issues will be solved by the team, and after solving those issues, there is a proper format of memorials that I hope this whole is a very different, it requires a very different session on it, in which you get to learn how to write good memorials, because good memorials are very, very important. But to get the basic understanding of it is that you get to prepare these memorials by solving the questions that are given to you in the moot problem. Now, whether moot problem is based on international law, whether moot problem is based on national law, sometimes it is really difficult for the students to solve those questions, because sometimes you will get all the facts relating to one question and not even a single fact relating to another issue. So that you have to play very smartly to do the research and just answer that question. It's all take those issues as a questions, I would say, and don't take them as a, basically those are prepositions, but what I understand and how it's easy to solve them is just take them as a questions and just solve them with your research and application of the facts. So remember to apply facts on each and every issue. Don't just rely on the case laws, don't just rely on the law. You have to apply the law very efficiently, and that you will learn in your, I hope there is a session for this in which you can get to learn how to solve these questions. And the second stage, which is the oral arguments, I have already spoken about it. In this stage, you get to present your case. Now here you have to be very smart about it, because the whole memorial is, if it is of 20 pages, you are not going to present 20-page memorial in just 15 to 20 minutes. Most of the competition give time, 40 minutes time. So each speaker have taken 20 minutes divided. And in those minutes, you cannot present 20 pages memorial to the judges. So you have to really pick and choose what you have to present before the bench, and you have to just be smart about it. When you will prepare for the oral arguments, you will get the understanding of what you have to say, what you have to skip, and most of the things I would say you have to skip from it, because you don't have time for that. So you'll have to just rely on your strongest arguments and the issues, and not rely on the persuasive or perhaps stuff that does not help you very, very much. Now, how can you start preparing for it? Now, this is very important. You got the moot problem, you submitted your memorial, or perhaps you have not submitted your memorial, you got the moot problem. Now, at the very first stage, what you need to do? Now, I am going to tell you about what do you take at the very earlier stage of the competition. Now, since we are understanding the basic of it, I am going to stick to the basics of it. Now, you get the moot problem, you and your team have to now read that problem. Know your case in and out with relevant laws. Now, what I mean by relevant laws is that every moot problem have law mentioned at the end of it. So it's not that you are given a moot problem, bunch of facts, but the law is not there and you have to just find out what law is applied and just do everything on your own. That's not the case. At the end of every moot problem, last paragraph after the issues, or perhaps before the issues, last paragraph talks about what laws are involved. For example, if the Geneva Conventions are involved, they will tell you at the end of the moot problem that 4 Geneva Conventions and their protocols and every United Nations Charter and all the other laws that are involved if it's international law case problem. So yeah, you'll get the laws at the end of it. So now what is your responsibility? Your responsibility is to firstly read the case, and then read the relevant laws. Take out all the laws. Just go through those laws so that you understand that where is this problem heading to. Competitions like Jessup, you get 40 pages moot problem. So it is really difficult for you to just understand that whole problem in 2 to 3 days, or perhaps a month. That is why they give 6 months for the preparation of Jessup. In a Jessup competition, you get 6 months before the competition is held. You get more problems 6 months before that. So during those months, till the last time discover new facts in that problem. So some of the competitions will have 2-page moot problem, and some of the competitions will have 40 pages moot problem. You need to know the facts more than the judge knows, because that's just basics of it. You have to know every fact of your moot problem, what parties are, what issue is, what is it related to, what laws are mentioned, and what does issue talk about. These basics students have to have. Then there comes research well, know every single concept that you quote. For example, if you're quoting genocide, know what genocide is, what law is applied on genocide, what are the elements of genocide. If you're quoting any crime, know what are the elements of that crime. If there is sea issue, know what are the limitations, what are the laws applied on the sea or sea problems, international sea law, what is the international sea law, everything. Research well. Now, by research well at this stage, I don't mean to say that you have to solve it then and there. I'm just saying that you read the moot problem, you read the law, now you have to just do the basic research of it. But while you present your case, while you solve your case, you have to know every concept of it. If you're quoting anything, any basic concept, even if you are quoting a word, you need to know the meaning of it. By quoting, I mean if you're speaking in your pleading and you're quoting that. I don't mean to just say that whatever words you have mentioned in the memorial, you don't have to remember every word in the memorial, but you have to remember every word that you say, meaning of every word that you say, understanding of every concept that you say. So yeah, research well, and then there is assume roles, take responsibility. Now this is again very important and very, very, very important perhaps I say responsibility on every participant, that you have to assume roles. Now if the issues are divided between you, that A is going to prepare for issue 2, B is going to prepare for issue 3, and C is going to prepare for issue 2 and 3. So now what happens is that all 3 of you have a different responsibilities, but it does not mean that the other person is not going to help the other teammate. It is really important for teammates from the beginning of the competition to sit together and discuss the moot problem. Discuss it with your participant. Because what happens is that every participant deals different issues, but all the issues are connected. Always remember that all these 3 to 5 issues are definitely connected, and there is nothing that could differentiate them. Not even a single issue can be solved without the help of research on the second issue. So just understand that after the participation, you got the moot problem, you read it, now you have to discuss it. You have to just defend each other in the conversation. You have to assume roles as if you are just defending the applicant. If you are solving the applicant and the other counsel is solving the respondent side problem, just engage with a healthy debate. Engage with the arguments that I am going to say this. I am going to say that this element of genocide crime is not fulfilled, but the other will say that it has been fulfilled, and you'll ask how is it fulfilled, and that the other person will guide you that this way it is fulfilled. Now it's your responsibility to defend that, because now the argument has come up that the client or the person or the entity in whatever it is in the moot problem that you are representing is going to be held accountable on the basis of this argument. Now you have to come up with the counter of this argument. So this is extremely important, where you take responsibility, and if the other person knows the answer, it will give you the answer as you have to give each other the answers as well. Now this doesn't end at the basic level. This goes till your oral arguments. For example, if senior counsel number 1 is presenting the case, and the judges ask some of the questions that the counsel doesn't know, after that the second counsel from your own team will go. Now if the second counsel knows the answer, or perhaps in the meantime have obtain the answers while you were presenting at the podium, then they can come to the podium before starting to their own pleading. They could ask the bench that I would like to seek permission to answer the questions asked by my co-counsel, asked to my co-counsel. So yeah, the judges will obviously allow you to answer those questions, and in that way, you just make your team fulfill the requirements that the judges have with you. You just take the responsibility of the first counsel and answer those questions, and the same will go to the researcher as well while researching, not while the pleading, because the researcher are mostly not allowed to plead, but both the speakers, if there are two, if there are four, can just assume roles and take responsibility of each other's without making others feel bad. So at this point, you have to be very, very smart about it, and very, what do we say, that very responsible about it, that the other counsel, the reputation of other counsel is not at stake, because the judges are going to notice that if the second counsel has come and he or she has said that I'm answering because my second counsel could not answer, that is also a very tricky position. So you have to think about it. You have to analyze the situation, that where it's possible for you to answer those questions or not. Sometimes the judges don't allow you to answer. Judges will say just proceed with your case, and that is also absolutely fine. You don't have to just keep saying that I want to answer if the judges are not allowing it. But there is a possibility that you can just go there, and before starting your own pleading, you can say that I would like to answer questions asked from my co-counsel. So yeah, the responsibility of each speaker continues till the last stage, from the beginning till the last stage. So you have to assume roles, and you have to be very, very responsible for that. Second, what I would say is practice time management. Time management is a very basic skill in moot court competitions. Time management is one of the most important yet basic skill, which often we neglect to focus on. We don't focus on time management. Remember that competitions like Jessup, Henry Dunant, Nuremberg, your time is very important. Your time can just discard you from the competition. Your time can disqualify you if you take a lot of time. If you're not good at time management, this will give you a lot of negative points. So I have judged several moot court competitions, and I would like to let you all know that every competition score sheet has a column that says time management, not for the team, for each speaker. So we have to give marks on that particular point. In order for us to give marks for that, most of the team does not focus on that, because people don't know that it is a very important thing in the moot court competition. It teaches you how to manage time. I myself was a debater firstly, then we used to practice about it, and everybody has. If you're participating in moot court, you have to focus on time management. Now, how you can do it? You can just. So during time management, you also learn that what are the strongest argument. If I have my issue solved in 7 pages and I have 20 minutes, I would not be able to read 27 pages in 20 minutes, or perhaps present them with the judges asking the questions in the middle of it. So by time management, by practicing it, by time managing it, by keeping the record of it, I get to scrutinize my pleading. I get to scrutinize what are my arguments, what are my strongest arguments. I do not need to present the whole pleading of 20 pages or perhaps 7 pages. I just have to present I just have to quote the definitions. And in the meantime, I have to just rely on 2 to 3 case laws. You don't have to rely on 50 cases on one issue. You just have to rely on 3 to 4 cases, and then just submit those cases before the court, and that's it. So that also is where time management comes to play. So during oral argument, what happens is that if you're given 40 minutes and the other counsel has taken, for example, 30 minutes and the second counsel has got only 10 minutes, then also the second counsel has to complete its speech in 10 minutes, its arguments in 10 minutes. You cannot. It was the first counsel who had the responsibility to just think about it and just practice their pleadings within 20 minutes and not take the time of other counsel. This happens very often. This happens most of the time. This happens, and the other counsels are left with 5 to 10 minutes where they usually cannot be able to just argue their issues, and that goes very negative. That impacts very negatively on the team, because the judges are noticing that you're not done with the pleading, you're not done with, if your time is up and the bailiff is asking that your time is up and your pleading is still not complete, despite the fact that you end your pleading and you say that I'm done, the judges are going to notice that if your pleading is not done, then you have a lot of things left to be presented and you are not good at time management. So just practice time management, just focus on the time management on the initial stage, and know that how much time each speaker is taking and how much time is divided to each speaker, so that none of the speaker get affected or their pleading gets affected by that. Have an interactive approach. Very important skill. Very, very, very important approach, in fact. Remember that moot court competition is not a debate competition. It is not a debate competition. It is a conversational speech, perhaps you can say. A conversation. You are going to go to the podium to have a conversation with the judge, whereby both of you get to solve a problem. It is not a debate competition. Most of the students, what happens is that they take this as a debate competition, and then it just negatively affects them. They just go to the podium, present their case, present their speech, and the judges, if there is a cold bench, for example, the judges are not asking questions, and you went there, you presented your case, and you came back, then also it becomes a big problem for the speaker, because that speaker presented it as a speech, not as a conversational speech. So that has to be a conversation between you and the judge, and both of you get to solve a problem. So you always from the beginning have to take an interactive approach. While solving the problem, you have to know that if I say this, the judge is going to ask this question. So sometimes knowing what the judges are asking, what the question will be, is also important. You deliberately leave some points for the judge to ask questions, so that you have the answer prepared with you, and you just put the question before the bench, and the bench automatically asks you that question. So you say that there are the genocide. My client has not committed genocide because genocide has 3 elements. So now you move on to further. Now the judge you deep down know that the judge is going to ask me what are these 3 elements, and I know the answer of it. So that way you have to prepare your oral pleading, rather than just presenting all the elements and just saying that this and this doesn't fall there. That is also very important. You have to just take an interactive approach. Don't focus on the pleading. Don't focus on what you have to say. Focus on what the judge will say. Focus on what the judge is going to ask after I say something. So yeah, don't entirely focus on reading or memorial. Have an alternate pleading for yourself. Improvise. Again, this you have to just learn during your preparation, during the initial stages of your oral. Once your memorial is done, once you send the memorial, now you have to focus on that. You have to focus on improvise. Now, why I have written have an alternate pleading for yourself is because I used to do that. I used to have different pleading for myself where I would just go and present that. Obviously, that cannot be different from the memorial. But I had one or two page of it, and I used to just write the definitions of just write the issues and the definitions and the pointers in which I'm going to rely. So that is a key point, that every speaker has to have their alternate pleading. That pleading have to align with the obviously with the memorial. Now, in alternate pleading, how you prepare it is that you write the timeline of the case, you write all the pages in the memorial, you don't miss out any page of the memorial that you are referring, rely on the memorial as much as you can. Take the judges to the page that you are reading or you are relying from in the memorial. So in an alternate pleading, some sort of 2-page summary of your pleading, of what you are going to say before the judge. So you'll have the memorial with you, and subsequently you will have the alternate pleading with you. You present your pleading, you present your case from that. That's just for the speaker's understanding, for the speaker's own self. Because for me, it helped me, and I used to do that. Some of you may just do that, and it will be really helpful for you all. Now, don't entirely focus on reading or on memorial. This is also one of the biggest mistakes that speakers make, is that they just read from the memorial. You are not supposed to read. This leads to the last slide that I shared with you, that it's not a speech competition whereby you just read and go to your seat. You have to be interactive. For you to be interactive, you cannot be reading lines, you cannot be reading paragraphs before the judges, because judges have to be very engaged with you. You have to engage with the bench. You are not the one who's just playing around. You have to engage with the bench. You have to just, even if it's cold bench, you have to just make them ask you questions, because speaker that just gets questioned out of the cold bench is very, very important, and the speaker has the ability to do so, then it's great. So if the bench is asking you questions, that's always a good thing. But if the bench is not asking you questions and they're just sitting there, they're just bored, then that can be a biggest problem for you. So in order to get the questions from the judges, you have to just be interactive. You can be interactive by not reading it, by not entirely relying on the memorial. You have to rely on the memorial for the research purpose, for your issues, but you cannot just rely on for your pleadings or everything on it. So yeah, that's it. And then observe everything and listen carefully what the judges have to say. The pressure in the moot court competition is real thing. The pressure is a lot, and most of the time you just get distracted. You are not focused in there you're not focused in the courtroom, basically. So what happens is that even if we are on the podium, we are pleading, the judge is asking several questions, we are not able to understand the questions. You have to practice listening to the judges, practice listening to the question, practice how you answer your questions, and observe everything. Now, once you entered in the moot court competition, your courtroom whereby you compete, you have to observe everything. Observe the bailiff. Talk to the bailiff, how he or she going to remind you that your time is up, how he or she is going to just ask you that if you have to give any judgment to the judges, how you can approach the bailiff to give that judgment to the judges, or any document that you have to go. So you have to enter the courtroom and observe each and everything before the starting of the session. You have to observe everything, and later on you have to listen judges carefully. If the judge is asking you questions, just listen to it very carefully. Don't rush to answer. Be very patient with the judge, and just just listen. And if you don't understand the question, ask the judge to rephrase, ask the judge to just ask another time. I remember once I asked the judge to just rephrase their question for 15 to 20 times, and the judge kept rephrasing the question for me, and the same question. That was just because I was so pressurized by the whole environment that I couldn't listen to what he's saying, or even if I was able to listen, I was not listening it properly what the judge wants. So ultimately, I answered the question fine. Alhamdulillah, I knew the answer, but it was just the pressure. So the pressure itself is a lot. So you have to just be okay with the fact that if some question you don't understand, you have to ask the judge to rephrase, and the judges will be happy to rephrase the questions for you. So there is don't take it as that it's your negative point that you don't understand the question or you ask the judge to repeat the question. It's always a positive, and the judges don't take it very seriously. Or presence of mind. Now this is again connected to the last slide, that presence of mind is really, really important for you all. During the competition, you get pressurized, if you quoted a judgment and your researcher couldn't find the judgment, the other speaker couldn't find the judgment, you get a lot of pressure then and there. So you have to be very, very present there, that if there is no judgment, no copy of the judgment, you give your own copy of the judgment and you ask the bench to just read it or to just rely on it. So know that what is going on around you, how you can, if you can ask the help from the researcher, if you can ask the help from your co-counsel, it's always very important, and it's for the speaker to understand whether those people will be helpful to you or not. That is also very important. You cannot embarrass the researcher or yourself asking that my researcher will provide, and if the researcher doesn't have anything to provide. So you have to just think about it and just know that be present at it, that if I ask the help from the researcher, whether he or she will be able to provide that assistance or not. Communicate well with the team, know what are the skills, how good your team is, how much you can rely on the team. That's again the basics of it. The pressure is real. Moot court pressure from the time you get the problem till the presentation of your arguments. It's a lot of pressure. Students from first year or till final year, you will think that you are getting distracted by it. You'll think that you are just, this is not useful. You will think that this does not help you. But trust me, this will help you big time. You will learn a lot of things from the mooting, and this pressure that you will get in the moot court is nothing as compared to the pressure you will get once you are graduated. So just know that this pressure is not the 5% of what you are getting, what you will get after the graduation. So the pressure at that time feels like you're not able to focus on your studies because of moot court competition. You're not able to focus on anything else, but that's all fine. All of us can do both study and participation on the go. Like, we can do it. And when it comes to the pressure, you have to sustain the pressure, and once you sustain that pressure and succeed in those competitions, you will get the hand on it, and there will be no way to stop you. You'll start having fun in a moot court competition rather than considering it pressure. So just be consistent with it, be patient with it, that you have to you will enjoy it at some point. Because if I tell you, in my first year I participated in virtual moot court competitions, like 3 to 5, those were from India, but I couldn't do good at it, and I was just participating for the sake of learning it. It was a lot of pressure. There were only 3 to 4 days in the memorial submission and last minute registration, but I had to just participate in it. And those competitions which I did not won, which I did not even participated well in them. But I learned a lot of things, and those competitions gave me confidence to participate in international competitions. So yeah, it's always, the pressure is always helpful, and it will help you later on while you're in your participation. You'll start enjoying those competitions and rather than considering it a burden. Okay, so now that we have come to the end of our sessions, I have pretty much covered all the basics of it. I hope everybody got the understanding of what it is, what are the stages of moot court competition, why are they important, and I would surely encourage everybody to just participate in it. At this point, I would like to ask you all to ask questions, because I to answer all. I'd like to answer all. So yeah, go ahead, type your questions or just raise your hand on the mic. I'll be happy to answer.
Thank you very much, Mr. Urooj, for sharing your invaluable knowledge and experiences with us today. So, as Mr. Urooj said, before we conclude, I encourage participants to please unmute themselves one by one if they have any questions, or write them in the chat box. So, I see we haven't received questions from participants yet. So I have a few questions that I believe every first-time mooter would find valuable. Could you please answer those, Mr. Urooj?
Yeah, sure, definitely.
Yeah, okay. So it's my personal question, and I hope everyone has that question. So how do you balance academic studies with preparing for moot court competition?
Yeah. So see, the participating with such activities, you have to manage your studies. I mean, I had to manage it, like I had no other responsibility. I left all the responsibility except moot court participation and then the studies. I used to skip classes as well, so the institute has to help us a lot in those participations. Our institute was like that. If we don't take some of the classes, they will give us extra classes for that when we are done with the competition. So that kind of a support was given by our institute to us. That helped us a lot, and same you all can demand from the institute that they give you that support, that if you are not able to take certain classes, you still get the attendance of it, and then later on same classes you can request those teachers to teach you specific topics those you miss. So that's one thing. And if you have exams, obviously you can just say that I remember I just refused to participate when there were exams. So that is also something that you have to just say. Most of the competitions do not come during exams. That's also a thing, that a lot of competitions comes at one together, so that you don't have to they don't clash with your exams. Then if they clash, then obviously your exams has to prevail. But yeah, the institute has to provide you support too. Since you're representing the institute, you have to just demand whoever the principal and whoever is director, you have to demand them that there are certain teachers or the classes that we would not like to attend, and we will require the attendance of it. That our institute was kind enough to give us that attendance. I hope yours is as well. Or if not, then you will have to give extra time for that. I used to remain awake all nights, and I used to prepare. I used to just walk and do pleadings all by myself. So you have to do that. I mean, again, I said pressure is real. So once you participate in 2 to 3 competition, then there is no pressure. Then you try to enjoy it. Then you get bored by the studies and then just participate in moot court competition. That also happens.
Okay, so as you have judged the competitions too, so I want to ask, what are some common mistakes that you see mooters make, and how can they avoid them?
Yeah, so I covered some of them, but I would like to quote as well, that one of the mistakes is time management, that students don't focus on. They think that if we ask the judge to give us 3 to 4 minutes at the end of it, the judge will give you that. Mostly judges will give you, but they cut your marks when the when the score sheet comes for the time management. So you don't know. I myself give 5 to 6 minutes if the students are asking for it. But when I score the participant, I obviously deduct their marks in the time management because they asked for the time, and even if the questions are not asked enough. Most of the time people say that there are a lot of questions that took time, but if there are no questions that are being asked, that doesn't make sense that you're not good at time management. So everybody has to focus on the time management. And the second thing is listening to the questions, observing everything what the judge is asking. Don't just rush to answer. I know there is a pressure on the podium. You have to just get done with the question. You have to just say that I should just blurt out the answer and just move on. But you have to be very patient with it. You have to listen to the question and try to answer it. Even if you don't know it, you have to answer it some way or the other. Don't say pardon me or such words, because these words people say that you can say, but I would say that don't say such words. Just try to answer the question as much as you can. If you can answer directly, that's helpful. If you cannot, then just mold the answer and just present it. Get away with it. Find a way to get away with it, but you can't just ignore or ask for the pardon. So yeah, that's the second thing. Third thing that would be having to quote the memorial. Yeah, understanding of the memorial is again very important. So if you are presenting issue 1, take the judge to the issue 1. Take the judge to the page number that's there. Ask that I'm reading from page number 2, page number 2, page number 3, page number 4. Take the judge along with you so that if they have questions, they can ask the questions at then and there. So just don't go on your own, because again I said it's two-way thing. You have to make it interactive, you have to make it conversational. So just tell the judge what you are saying and where you are coming from. So these are few tips. Other than that, decorum is very important. Competitions like Jessup and everything, you have to have a decorum. You can't just go with the flow. In national competition you have leverage, but competitions like international, you don't have. Your every moment, your every appearance, your every gesture is noted. So there is on the Google you will find Jessup guide. I would encourage you all to go through that guide. It will teach you how to be in a competition, how to be in a courtroom while you are coming to participate, and everything. There's this Jessup guide which is really good, and I give this most of the students I share with. So you all can just go on a Google and search for the Jessup guide for moot court competitions, and it's a whole book for that. Yeah, that's it.
Okay. So I see we have a question in the chat box. Yeah. I'm going to read that out loud so you can answer that. It's by Sneha. That can you discuss or share a moot court competition that had a significant impact on your career path?
So thank you, Sneha, for asking the question. One of the competition that had significant impact, in moot court competitions, every competition has a different impact on you. You just get a very, very different feeling after participating in different competitions. But one of the grand experience, I would say, or significant experience was my participation in Jessup. So in Jessup, what happens is that you have 4 speakers, and two on the applicant side, 2 on the respondent side. So 5 teammates, 1 researcher, 2 on the applicant side, 2 on the respondent side speaker. So if your role is that you are applicant and the other team is respondent, other team from different institutes is respondent, so you have the 2 speakers from your side, 2 speakers from their side. And it's the same with the role reverse as well. So in that competition, I was one speaker who was playing 2 roles. Like I was with the one speaker for the applicant side as well, and 1 speaker from respondent side as well. So I was playing both the side. I had arguments, and I was just reversing my arguments when I was presenting applicant's case, and then I was presenting respondent's case. The ideas and what you had to explore. That competition had a very significant impact on me, and plus that Jessup is very tiring competitions. From 9 morning 7 or 8 till I guess 9 or 10 you have evening, you have rounds. So you have 4 rounds from the applicant side that day, 4 rounds from respondent side that day. So you have to just be there, shuffle the row. I was just shuffling the roles and participating both sides. So that was very, very tiring and very, very impactful as well, because it taught me a lot of things and taught me a lot of my abilities, that what I can do. I mean, if I can participate in Jessup and present both the sides, I can participate in any competition, I would say. So yeah. So I would like to encourage you all to have at least one time experience of Jessup to understand what it is, since it is very rigorous competition. So yeah, we have I hope, Risha, I'm pronouncing the name correct. How can one enhance persuasion skills during oral arguments, and what tips can you offer for effective practice? Thank you. Enhanced persuasion skills. Now, all these skills throughout the competitions, you will enhance your skills. If you participate in one competition, you don't have skills. Remember that if you participate in moot court competition, one competition cannot decide if you're a good mooter or if you have all those skills or not. If you participate in one competition, you fail. You participate in second competition, you fail. But one thing that remains there is always that you get to learn very new things, new skills in all those competitions. Like I said, every competition in my experience taught me a lot of different things. There was not even one thing. I learned in the first competition that you have to answer directly to the judge's question. In the second competition, I learned how good it can be and how good I can answer the judge's question directly as well as persuasively as well. So every competition will teach you new things, and those skills that you already gained from the first competition will be more strongly and more effectively applied in the second competition. So remember that your participation in moot court will be very different in every competition. One thing that remains there, that your persuasion skills get very, very strong and very, very, very strong and very just they keep with you. You just learn new things. And during oral arguments, because the judges keep coming different in every competition, every judge has their own mindset. So to tackle with their mindset, to tackle with different judges' mindset, is something that teaches you a lot. I mean, it's and if I say effective practice, you also have to have these skills, and you get to just experience different judges. So if the one question is important to the one judge, the same question is not important to the other judge, and the different question is important to that judge. So now you have to answer all those questions, but to the different persons, and how they perceive is very different. So, and another thing is very important, that in moot court competition it is very important what you are saying, what you are in oral pleading. It is a very important skill that you get to pick and choose your words very carefully. You can't just say anything before the bench, because if you have deep down, you have this thing in your brain that if you say anything, there will be a question from them, because the question comes from your oral pleading. The questions do not come from your memorial. The questions do not come from judges themselves. They always come from whatever you are saying. So you have to really scrutinize your words. You have to be very efficient with the words that you say. That these are skills that actually help you in the effective practice and in the long run as well. So yeah, I hope I answered your question, Resha.
You answered it very well, and thank you so much, Mr. Urooj. Your expertise has truly enriched our understanding of mooting. I myself learned a lot of new things from you, and I hope our participants did too. So, with that, we have come to the end of our webinar. Thank you so much for joining us.